consent motion to withdraw, except Ms. Regis, who is present and representing herself, objects. So I'm going to hear from the parties. You can just have a seat right there, ma'am.
Okay, thank you. Good morning. Thank you.
All right, Ms. Oldham, I'll hear from you in regard to your motion to withdraw.
Yes, Your Honor. I was retained by my client to represent him in a custody matter. We did have a temporary custody hearing. The order has been entered. My client no longer wishes for me to represent him, and he's asked for me to withdraw. He signed a consent to withdraw. There are no matters presently on the calendar at all, so we're asking the court to allow us to withdraw with the consent of my client.
Okay. Ms. Regis, I'll hear you.
I wanted to, do you want me to, I just want to make sure I'm in order. Do you need me to stand? I can stand.
Yes.
Okay, no problem.
Well, are you objecting to Ms. Oldham withdrawing from
Yes.
Mr. Devereaux's case, and why are you objecting, ma'am?
I'm objecting, Your Honor, because prior to the hearing, her office received a total of 7 emails from me. Oh, do you need me to speak up?
Can you speak up, please, just so the...
Prior to the hearing, when she was first retained, Miss Ashley was sent 7 emails from me that was not responded. I gave her 3 Google Drives that showed that there was domestic violence. The addresses were purposely wrong, but mainly that the timeline that he stopped the relationship was purposefully to file this petition just so this court can put in the system that the relationship ended in 2021. The relationship did not end in 2021. The blockage that he is, I actually brought the synopsis of the criminal complaint.
So, ma'am, I'm not getting into the facts of the case. He does not want Ms. Oldham to represent her, or he does not want Ms. Oldham to represent him anymore. She's asking to withdraw as a result of that. I have his signature consenting to her withdrawal. So do you have any reason why she should still have to represent him even when he doesn't want her to?
Because she allowed him to continue to escalate. She even assisted him in escalating. She assisted him with fraud. So to release her in the middle while your signature is on something that is harming us, I think that is irresponsible. And from my understanding, he didn't ask to withdraw. She asked to withdraw.
Okay. All right. So, ma'am, I hear your objection. I am going to grant Ms. Oldham's request to withdraw as attorney of record. All further correspondence need to be to Mr. Devereaux or counsel if he has an attorney, okay?
You said, can I say something?
Yes, ma'am.
I know we're discussing about her being withdrawn from the case, but based upon the information on the case, the origination of the case, it's all based upon false information. So it should be, the petition is false. The petition is all fraudulent.
That's not on the calendar today. The only matter that is on the calendar is whether I'm going to let Ms. Oldham to withdraw as his attorney. So any matter about a false petition, any other defense that you want to assert, that is not on the calendar
It's not a defense. It's factual. Your office actually has.
But what I'm saying is that issue is not on the calendar. Okay, the only matter that is on the calendar, if you look at the calendar for today, there was a calendar request and notice of hearing for her motion to withdraw. That was it. I'm not determining any other issue other than what is before the court.
No problem.
Okay? All right, so I'm going to grant your request, Ms. Oldham. I went ahead and signed the order. Now, Ms. Regis, I will say one thing. The court cannot correspond, and you'll stay on WebEx for a second, Ms. Oldham. The court cannot correspond with you ex parte, which means without the other party being attached to the information. I know that you have sent numerous emails to Madam Case Coordinator.
With the attorney inside of the email.
Madam Case Coordinator can't address anything other than maybe scheduling. Okay, so any matters that are not related to the purpose of Madam Case Coordinator, please do not email her about. Okay?
Okay.
All right? Because she has a lot that she has to do. She tries to be respectful of everyone's time and respond to the emails, but a lot of the times there's nothing that she can do about what you're sending her. Okay?
I didn't have her email. I was given her email in a CC copy.
I'm just saying, so everything runs smoothly and we can hear everyone's case that's on the docket and we can try to get through including your case. Please, only as it relates to matters that she can address. You can obviously reach out to her. But if it's anything additional to that about what you're saying is a false, well, I know you're saying that it's true. I'm just saying any allegations, she can't address that. That's for the court, okay?
So in situations with a pro se litigant, when I'm asking, so I can make sure that I do not do this wrong,
Sure.
if I filed something incorrectly, is it the responsibility of the coordinator to let me know
No.
that something? Gotcha.
No, and I mean, you're acting as your own advocate. The court treats you just as if you were an attorney. It's not her responsibility to tell you how to do things. We do have the legal support center downstairs on the first floor. They can help you, but it's not her responsibility to help you navigate through this process, okay?
So if I emailed her and I asked her about something that was filed that I was, of course, that I was misunderstanding what it was, is she supposed to respond at all?
I can't get into.
All right, I'm just asking.
You're fine. All I'm trying to do is.
I want to make sure I stayed in order. You know.
I'm just trying to limit the amount of communication because I know that she's receiving a lot of communication from you, which ordinarily, I get. You know, I know you represent yourself, but if it's not something that she can address, then she doesn't have to respond. If it's something about scheduling, then obviously that's something that she can respond to. But anything about telling the judge or anything about, you know, your defenses to the matter, she's not going to be able to respond to those, okay?
Gotcha.
So I just wanted to say that on the record. All right, so I don't have any future court dates at this moment. Ms. Oldham, I'm going to allow you to withdraw, and I sign the order to withdraw, okay? All right, thank you, ma'am. Thank you.
Thank you.
All right, next matter before the court is going to be line number 3, Danielle Padgett for Ray Padgett, third, file number 13CD0033707. Present in the court is plaintiff for Ms. Luann, is it Van Luann? Yes, sir. Van Luann and Ray Padgett here.
Sorry.
The court finds that Mr. Padgett has been served with the plaintiff's motion to terminate child support and is not present. Are you ready to proceed? Yes, sir. All right, you all have some right there.